evening to all of you friends. A very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. A very good evening to each and every one of you watching me live. Welcome to one shot revision for ALIT and CLAT 2023 examination. So friends, today we are going to discuss some very important legal issues which is absolutely important for each and every one of us preparing for ALIT and CLAT. With just a couple of days for ALIT and just over a week's time for your CLAT examination, it is absolutely important that you guys are aware of some of the very important aspects, topics on legal reasoning. Apart from discussing with you some very important legal reasoning concepts, I shall also be deliberating on, and definitely we will have a question and answer round about three important topics. So a very warm welcome to all of you. I would expect more and more students to join us right now. So guys, let's begin with this very important session. Let's look at the agenda for today. The agenda for today is law of torts, law of contracts, and Constitution of India. So these are the three topics that we are going to talk about in this particular session. Okay, so we are going to understand some very important concepts of law of torts, then we will move on to contracts and constitution, and then we will have three passages which will be very important for all of you. So guys, let's begin with law of torts. Now, what is the meaning of the word tort? The word tort means a civil wrong, okay? Then we will move on into the features of tort and the essentials. So the meaning of tort, first let's understand what is the meaning of tort. Tort means a civil wrong. Okay, a civil wrong. So only for a violation of your legal right. So in case there is a violation of legal right, you can claim compensation. And this compensation is in the form of unliquidated damages. That means it is the court which is going to decide how much compensation you will get. It is the courts that is going to decide. Then we move on into the features of tort, the essentials of tort, and the difference between civil wrong and criminal wrong. So in this session, I'm going to just give you an overview of what are these important things. And finally, we shall talk about the various defenses that are available under tort. They are also called general defenses. So first, let's understand the meaning of the word tort. The word tort has been derived from the Latin term called tortum, which means an act that is twisted. So an act that is twisted is called tortum, and from the word tortum, the word tort has come into being, and it refers to civil wrong, not criminal wrong. Mind you, it refers to civil wrong. A tort is an act or omission other than a breach of contract which leads to an injury or harm. Now over here, injury or harm means legal injury. Legal injury. So violation of your legal right is called injury or harm to another person and amounts to a civil wrong for which liability is imposed. Very important. Please note these things down. So the word tort amounts to an injury to your legal right for which liability is imposed by the courts. And if the courts are satisfied that a person's legal right has been violated, then the court will grant compensation. Is that clear? Is that clear? Whatever is given over here, is that clear? Okay. So that's what I said. When a wrong is committed, the courts will award some damages or compensation. This is called unliquidated damages. Is that clear, each and every one of you? Am I clear to each and every one? Okay. Okay. All of you? Brilliant, brilliant, brilliant. Now, moving on. Because in this particular session, you will get a revision of what is there in your syllabus and you will understand. And if you have any doubts, definitely you can ask me. Now, the remedies are always civil in nature. That means you are only entitled for compensation. You cannot ask for punishment. Now, in criminal law, now I'll give you an example. A lot of you will have this doubt. Sir, defamation is civil and criminal. Yes, defamation, the offense of defamation is both civil and criminal. Now, if you go to the civil court, you are asking for compensation. You also have a right to go to the criminal court. Now, if you are going to the criminal court is not going to award you compensation, but is going to award the other person punishment. Simple imprisonment, rigorous imprisonment, whichever punishment it may be. Am I clear on this? You have a right to go to both the courts. From the civil court, you will get compensation. From the criminal court, the other person will be given punishment. Am I clear on this? Every one of you. Everyone. Okay. Brilliant. 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 Fantastic. Let's move ahead. Now let's understand the features of tort. Now, tort, the law is uncodified. That means the Indian Parliament, the Indian legislature, the Parliament has not yet created a particular legal text on it. This law is based on judgments of courts in England. So here we are talking about this unique feature of tort. Tort is not codified. You do not have a Indian Tort Act. There is no such act like Indian Tort Act. You have the Indian Contract Act, you have the Indian Penal Code, you have the Motor Vehicles Act. But do we have an Indian Tort Act? There is no such Indian Tort Act. So that is called uncodified law. As I said, this part of law has been developed from various decisions of various courts in England. And it is based on the common law jurisprudence. Now, what is common law jurisprudence? Common law means laws that were common to the Commonwealth countries. India, Australia, Canada. So these are all common law jurisprudence where once the British Raj ruled. Am I clear? These are places where the English or the British Crown ruled. Now you have the Commonwealth Games which is played by all the countries which were once under the British rule. So common law means the law that was common to all British ruled countries. So that is the basis of civil law in India. Now we can't forget this fact that even in India was even ruled by the Britishers. So most of these things that we have today, the civil law system is based on common law jurisprudence. Another very important feature is the fact that this law of tort is purely based on this particular principle of law called ubi jus abi remedium, which means if a wrong is done, suppose your rights are violated, there is a remedy for that in the eyes of law. So wherever a wrong is committed, whenever a wrong is committed, there exists a remedy in the eyes of law. For every wrong, there exists a remedy. This is the principle on which the entire concept of tort is based. Am I clear? Have I made myself clear to each and everyone? Have I made myself clear? So guys, if you are liking this session, do press the like button. If you are liking this session, do press the like button and show us some love. Okay, great, fantastic. Okay, so all that we are trying to say is the fact that here is a particular law. Here is a particular law which specifically deals with violation of an individual's legal right. Am I clear? If your legal rights are violated, you have a remedy, that is compensation. Yes, Neha Malik. Explain common law jurisprudence. Common law jurisprudence simply deals with the fact that certain laws that were common to all the Commonwealth countries, all the countries that came under the British Crown, they had similar law, and that is called the common law system or the common law jurisprudence. Now, our civil law, the civil law that we have today, is based on this common law system. Am I clear? Okay, moving on. What are the essentials of tort? Very important. A wrongful act or omission. You are supposed to do something under the law, you did not do. You are not supposed to do something under the law and you did it. So an act or omission. You were supposed to act, but you did not. You were not supposed to do something, but you did. So if a wrongful act or omission which leads to a violation of a legal right. So an act or an omission that leads to violation of a legal right are the essentials of tort. Is that clear? Everyone. So all that I'm trying to say is the fact that every wrong that is committed which leads to a legal injury, is called a tort. Okay, am I clear, everyone? Okay, brilliant. Great to see you. Now, right to claim compensation. Right to claim compensation arises out of a violation of a legal right. Now, this particular right to claim compensation, when do you have a right to claim compensation? The answer is simply this: you will have a right to claim compensation only when you convince the court that someone's action or omission has led to violation of your legal right. So you have to go to the court and tell the judge that my legal rights have been violated owing to the acts or omission by someone else. And if the court is convinced that there is a violation of your legal right, the court will award unliquidated damages. Unliquidated damages means not previously determined by the parties. It is to be determined by the court or by the judge. How much of compensation are you entitled to? How much of compensation are you entitled to? Who is going to decide? Who is going to decide? It is the court which is going to decide. Am I clear? Every one of you. Everyone. So the court is going to decide how much of compensation you are entitled for. Okay? Very important. Determining liability in tort. Now, this is very, very important. Now, where there is a breach of duty. Now, every person has a duty towards someone else. I am living in my apartment. I have a duty towards my neighbor. Can I play my sound boxes so at such high volume that my neighbor is unable to sleep? No. A doctor has a duty of care towards his patient. Negligence, nuisance. So, liability in tort arises where a duty is violated. I have a duty of care towards my neighbor. The bus driver has a duty of care towards the fellow passengers. When you are riding a metro, you have a duty of care towards your fellow passengers, right? Am I clear? Is that clear? So, the liability, the concept of liability arises when during the time a duty of care that is vested under the law is violated or breached. So, breach of duty of care arises to tortious liability, and the court may award unliquidated damages, compensation. Am I clear? Everyone, any doubt, you are most welcome to ask me. Okay? Is that clear? So guys, if you're liking this session, do press the like button. Okay? Do press the like button, guys. Do press the like button. Okay. Brilliant. Brilliant. Moving on. Examples of breach of duty of care. A doctor has a duty to take care of his patient, which includes treatment with the best skills and knowledge. Now, when a person falls sick, he goes to the doctor. Now, if the doctor is careless, if the doctor is not taking duty, he has certain duties. If he is negligent in his duty, and suppose the patient suffers some harm, the doctor will be liable. Medical negligence. A bus driver has a duty of care towards his fellow passengers. Now, the bus driver cannot drive the bus in such a manner that the fellow passengers who are sitting collide with each other and half of them die or get injured. No. Is that clear? So, a bus driver has a duty of care. A doctor has a duty of care. A manufacturer of a particular goods has a duty of care towards the customer to manufacture proper items. Now, suppose you are manufacturing Maggi or a soft drink. You have a duty of care that this drink or this noodles is good for health. You cannot use substandard goods. So there is manufacturer's liability, doctor's liability, bus driver's liability. So person is entrusted with house keys. Suppose you have given your house keys for renovation of the house. He has a duty of care to lock the house when he leaves. Now, you have given your house keys to Mr. X and you say that, okay, I am going out for 1 month. There are certain repair activities that needs to be done. Take the keys. Now, can he keep the doors open and leave? No, he can't. That is what we understand as duty of care. Then comes civil wrong versus criminal wrong. What's the difference between civil wrong and criminal wrong? Now, civil wrong is a wrong against an individual, whereas a criminal wrong is perceived as a wrong against the society at large or against the state at large. In a civil wrong, the injured party claims compensation. In a criminal wrong, you are asking for punishment. Simple imprisonment, rigorous imprisonment, solitary confinement, death penalty. In civil wrong, the injured party sues the wrongdoer. Whereas in a criminal wrong, very important, it is the state which prosecutes the wrongdoer. There is this word called prosecution. And the state here is the injured party. So you go and file a case in the civil court. Over here, you are going to the criminal court. Now, civil wrong is much less gravity. Criminal wrong, much more gravity. Let's look at the examples. Negligence, nuisance, trespass. Then you have theft, murder, robbery, kidnapping. From the examples itself, you can understand the grievousness or the gravity of the two wrongs. One civil wrong and the other criminal wrong. Am I clear? If a person does not have a duty of care, then how can he breach that duty of care? Abhinav Verma. If someone does not have a duty of care, how, even if he does not do something, how can it be called a civil wrong? Keshwananda Bharati was a constitutional case. It dealt with the concept whether the parliament can amend any part of the constitution. Okay, Ishika Arora. The Supreme Court finally laid down that there are certain basic features of the Indian Constitution that cannot be amended, or that is beyond the powers of the parliament to amend the constitution. Okay, Ishika Arora, Abhinav Verma. Did you all understand? Okay. Can we move ahead? Can we move ahead? Can we move ahead? Tell me that. Or any other questions that you have in your mind? Any other questions that you have in your mind? Let me know. Any questions that you have in your mind? Okay. Okay. Let's move ahead. Let's go ahead. What are the various defenses in tort? They are two types of defenses. One is called general defense and the other one is called specific defense. Specific defense means, for example, in defamation, truth is a valid defense. So there are certain, for various specific wrongs, there can be some specific defenses. Whereas general defenses are those defenses which are applicable in all civil cases. So general defenses are available in all types of tort. Specific defenses are available in specific tort. For example, truth is a defense in defamation. So truth is not a defense in negligence or nuisance, but truth is a defense in defamation. So generally, defenses are of two types, general defense and specific defense. General defense are applicable across the board, every tort. Whereas specific defense is applicable only in specific wrongs. For example, a truth in defamation is a defense. Am I clear? Is that clear, everyone? Is that clear? Okay, good. That's great. Great to hear. In any question? Sir, trespass can be criminal also, is trespass criminal? Now, trespass to land is a civil wrong. Trespass to body is both civil and criminal in nature. Trespass to body is assault and battery. Assault and battery. Did you understand? It's assault and battery. Assault is the threat perspective. Whereas battery is the actual act of physically touching the other person. Am I clear? Is that clear? Okay. Yeah, trespass, yeah. Breach of duty. So, under the law, Shiada, under the law, in case the law says that there exists a duty on a particular individual, and if he does not follow that duty, he will be held liable. Okay, police officers can be held liable, but that will come under state liability. Okay, okay, let's move on. Now, what are the various general defenses that we have? We have voluntary non-fit injuria, act of God, statutory authority, plaintiff the wrongdoer, mistake, inevitable accident, private defense, and necessity. Now, the most important of all is voluntary non-fit injuria, act of God, private defense, necessity. Of course, questions do come from statutory authority, plaintiff the wrongdoer, mistake, and inevitable accident. But these four are very, very important. Now, what is voluntary non-fit injuria? If you have voluntarily taken up a risk, if you voluntarily have taken up a risk, you know the risk involved, and then you take part in it. I know that if I enter the boxing ring and I start boxing with my opponent, he might punch me on my nose. I might get injured. So, if I get injury, can I go to the court and claim compensation? No. Act of God is a natural activity with an unnatural force. A natural activity with an unnatural force. Private defense. Private defense means to protect your body or your property, you can use reasonable force. So, in case there is a threat to your body or to your property, you can use reasonable force. And the eighth one is called necessity. Necessity means you can cause a smaller harm to prevent a larger harm. To prevent a larger harm, you can commit a smaller harm. Am I clear? So these are some of the most important defenses that are there in general defense. Apart from that, you have statutory authority. I'm sure you guys are aware of. Plaintiff the wrongdoer. Yes. If the plaintiff himself has committed wrong, can he take advantage of the wrong that he has committed? No. Then you have mistake of fact, mistake of law. Mistake of law is not an excuse. Mistake of fact is. Inevitable accident means certain accident that has taken place which was inevitably happening. Statutory authority means suppose a police officer has been given an arrest warrant to arrest Mr. A, and he goes to Mr. A's house to arrest. Has he committed trespass? The answer is no, he has not committed trespass. Okay, is that clear? So these are the 8 general defenses. Moving on, specific defenses. Defenses of truth in defamation, rescue cases, etc. in voluntary non-fit injuria. Now, in voluntary non-fit injuria, there is an exception called rescue cases. I'll tell you this example. Now, suppose you know that that a house is on fire, and you are aware that in the ninth floor of the building there is a child. You go inside to save the child. You know that the house is on fire, you might get bodily injury, but still you go inside. You can claim compensation because that is not voluntary non-fit injuria. Because it is exception to the rule of voluntary non-fit injuria, rescue cases. Is that clear? Some people were asking me. Okay. If you are aware of a risk, that is not voluntary non-fit injuria, but you have to participate in that risk. The moment you participate in that risk, that is what we understand under voluntary non-fit injuria. Is that clear? Is that clear? Is that clear? Everyone? Okay. Good. Okay, that's nice. Okay. Okay, brilliant. Let's move ahead. Now let's come to contract law. Law of contracts. What are we going to study? Offer, acceptance, consideration, competency to contract. So what is an offer? What is acceptance? What is consideration? What is competency to contract? These are the most important things. So let's see what is an offer. Now, when one person signifies to another his willingness to do or not to do something. So if one person is asking someone else to do or not to do something with the view to obtain his assent or consent, that is called an offer or a proposal. Suppose I say, I want to sell my pen for rupees 100. I am signifying my willingness to do something with a view to get your yes from you. That is called an offer or a proposal. Am I clear? Is that clear, everyone? So the moment I say I want to sell my pen for rupees 100, I am signifying my willingness to get a yes from you. Now, there are various types of offer: general offer, specific offer, express offer, implied offer, counter offer, and cross offer. General offer, offer to the whole world. Somebody shouting on top of his voice and saying, Aloo 10 rupiya kilo. General offer. Specific offer, I make an offer to Mr. A. That is a specific offer. It is only for Mr. A, not for Mr. B. Express offer, it is an offer which is made by words, either oral or in writing. You are expressing. Implied offer, implied offers are made by conduct or gestures of the party. Counter offer, a person to whom offer is made does not accept the offer and he attaches condition. He is attaching certain condition. Cross offer, two offers at the same terms and condition cross over at the same time in ignorance of the original offer. Now, cross offer is I make an offer, the other person also makes an offer. That is called a crossover. I say I want to sell my pen for rupees 100. You say I want to buy your pen for rupees 100. We both have offered each other something. Is that clear? Is that clear? That is the concept of a cross-off. Is that clear? Yes, we will have a couple of questions. We will have 3 passages. Okay. Then you have standing offer. Standing offer is an offer intended to remain open only for a specified time. Very important. Okay. Only for 3 days there is an offer. Amazon has an offer for the next 3 days. That's called a standing offer. Now, what are the essentials of a valid offer? Offer can be expressed or implied. Offer can be expressed or implied from the conduct of the parties or circumstances of the case. Offer can be specific or general. A specific offer is one which is made to a particular person and can be accepted only by the person to whom it has been made. On the other hand, a general offer is made to public at large. Very important. Then offers must create legal relation. An offer must create legal relationship between the parties. So these are the importance or the essentials of a valid offer. I hope that you guys are understanding. You don't have much time. You have just 2 more days for your exam and for your A-Lit and just 1 more week for your CLAT. So just go through this. This is nothing but a revision. Apart from that, the offer must be clear and not vague. Now, you cannot go to a shop and you say that I want to buy dal. Which dal? Moong dal, masoor dal, chane ka dal, rajma. There are 50 different types of dals available. Right? The offer must be communicated. Now, it's very, very important that the offer is communicated. I say I want to sell my pen for rupees 100 in a closed room. Has this offer been communicated to Mr. B? No. The most important thing is the offer must be communicated. Offer must be different from an invitation to offer. Now, this is very important. What is an invitation to an offer? An invitation to an offer means the seller of the goods is inviting offers from a prospective buyer. I have designed my shop. I have kept in my shop many fancy things. You come to my shop. You say, I want to buy that pen. You come to my shop and you say that you are interested in buying that pen. I might say, I don't want to sell this pen. Is that clear? Just because you have money, you cannot buy everything on earth. That is the concept of invitation to an offer, so that the seller can say no to it. Okay? Is that clear? Okay. Fantastic. Moving on. What is acceptance? When the person to whom proposal is made gives his yes. The moment you say yes, when I say that I want to sell my pen for ₹100, and the moment you say a yes to it, that is acceptance. Acceptance must be absolute and unqualified. You cannot say, okay, I will buy the pen for ₹100, but I will pay in 2 installments. No. You have to either accept or reject. Acceptance must be communicated in the prescribed and reasonable mode. Now, if I say I am only going to accept your acceptance by email, if you have written a letter, no. You have to follow the terms and conditions made by the offerer. So if the offer has certain terms and conditions that only acceptance via email is allowed, then you have to just email. Am I clear? Every one of you? Every one of you? Yes. Yes, invitation to offer is not an offer. It is a kind of an offer which is made by the buyer of the goods for purchasing the goods. Okay? Okay. Okay. Acceptance must be given within a reasonable time. Acceptance must be given within a specific time, and if not time is specified, the acceptance must be in a reasonable time. You cannot just say, okay, I have made an offer. After 2 years, you come and say yes. No, you have to come in a reasonable time. Acceptance should be made before the offer lapses. Acceptance cannot precede an offer. Now, suppose before I made an offer, you have given your acceptance. That is not an acceptance in the eyes of law. Very important. Acceptance must be given only by the person to whom the offer is made. So, acceptance can only be given by that very person to whom the offer is made. It cannot come from a person to whom the offer is not made, specific offer. Now, if you want to reject rejected offer by accepted only on renewal, offer once rejected can't be accepted unless there is a fresh offer. Now, suppose I say I want to sell my pen and you say no to it. After an hour, you say yes. It is not an acceptance in the eyes of law. It is not an acceptance in the eyes of law. Am I clear? Am I clear? Okay. Everyone? All understanding? Okay. Okay. Good. Good. Then what is consideration? I say I want to sell my pen. For what? You give me something in return. So whatever you are giving me in return, that is called consideration. Consideration is the price for which the promise is bought. It gives a value for its enforceability. And agreement without consideration is void. So every agreement to become a contract must have a valid consideration. Then there is past consideration and present consideration. When the promisor has received something before the date of performance of the contract, suppose I say, I will sell you my pen tomorrow. You say, okay, for 100. You give the 100 rupees today and I give you the pen tomorrow. This is called past consideration. Present consideration, when the consideration is provided during the execution of that thing. Future consideration. I say, I want to sell my pen. And you say, okay, you give me your pen, I'll give you the money tomorrow. Future consideration. Am I clear? Past, present, and future. These are the three types of consideration that is valid under the Indian Contract Act. Okay. Am I clear? Okay, moving on. Capacity to enter into a contract. Okay. Under the Indian Contract Act, only people above the age of 18 can enter into a contract, provided they are of sound mind and they are not disqualified under a law. For example, bankruptcy, insolvency. Now, a person who is incompetent to enter into a contract, a minor, person of unsound mind, and person disqualified by law. So these are the people who are incompetent to enter into a contract and people who are competent to enter into a contract. Am I clear? A minor cannot enter into a contract other than for essential goods, food, water, clothes, warm clothes in winter, shelter, books. Other than that, a minor cannot go to a shop and buy a BMW car. But a minor can go to a shop and buy Parle-G biscuits. Because if he is hungry, he can have that food. Is that clear, every one of you? Am I clear? Now, let's move to law of constitution. Very, very important. We are going to understand basic structure, evolution, fundamental rights, Article 14. Now, what is basic structure? The basic structure of the Indian Constitution is federal. That means you have a union government and a state government. Both the governments have been vested with different powers. Union government will have different powers, state governments will have different powers. The basic structure provides supremacy of the Constitution. Whether you are A party, B party, or C party, you must follow the Constitution. There is a division of power between union and state governments. There is also an independent judiciary. You have the high courts and the Supreme Court of India, which are vested with certain rights. They have a power to issue writs, Article 32 and Article 226 of the Indian Constitution. Now, the evolution of the basic structure. Now, the first case is Shankari Prasad versus Union of India. In Shankari Prasad versus Union of India, the Supreme Court held that Parliament has the power to amend any part of the Indian Constitution. So in Shankari Prasad, the Supreme Court held that the power that is given to the Union Parliament is absolute. The Parliament has the power under 368 to abridge, to make changes to any part of the Constitution, including fundamental rights. Then comes 1965 Sajjan Singh, the same thing. Parliament has the power to amend any part of the Constitution. So both these judgments are same. Parliament is supreme. This also says Parliament is supreme. Both. Then comes IC Golaknath versus State of Punjab, It said that fundamental rights cannot be amended by the parliament. Parliament is not supreme. Parliament cannot amend fundamental rights. Article 368 provides procedure to amend the constitution, but it does not confer the power to amend fundamental rights. Very important. Note it down. Everyone. Then you have Keshwananda Bharati versus State of Kerala. It gave the great doctrine called the basic structure doctrine. Parliament has the power to amend the constitution, but there are certain very, very basic features of the Indian constitution that cannot be amended. So there exists certain very basic feature of the Indian constitution which cannot be amended. Federalism, election, socialism, secularism. Is that clear? Then you have Indira Nehru Gandhi versus Raj Narayan. It also dealt with the basic structure and certain clauses that was inserted by way of the 39th Amendment was struck down. Now, the 39th Amendment said that election relating to the President, Vice President, Prime Minister and Speaker of the Lok Sabha cannot be decided by the judiciary. Now, Prime Minister was Indira Gandhi. She faced a defeat before the Allahabad High Court. Justice Jagmohan Lal Sinha gave a judgment saying that her election is bad. She was disqualified. So she came out with this 39th constitutional amendment. Now this constitutional amendment after emergency was struck down. Then you have Minerva Mills. Minerva Mills said that the court struck down changes by the 42nd constitutional amendment on the ground that it violated basic structure. Now, by way of this amendment, the parliament made a law by way of the 42nd amendment that any amendment to the fundamental rights and directive principles cannot be challenged in a court of law. The court said that judicial review and balance between fundamental rights and DPSP is one of the basic features of the Indian Constitution. Now, it was this 42nd amendment which was done during Indira Gandhi's regime, said that in case the state makes a law based on directive principles of the state policy, it cannot be challenged on the grounds that someone's fundamental right is violated. The Supreme Court said fundamental rights are absolutely fundamental. They are basic to the Indian Constitution. You cannot make a law that violates someone else's fundamental right based on directive principles of state policy. Okay? Okay. Then you have Indra Sahani. Indra Sahani gave the reservation. It said that it upheld the constitutional validity of 27% reservation for OBC with certain limitation. And it said that the maximum reservation can only be 50%. Now, yes, today you have reservation which is around 60, 65, 70% across various states in India. The Supreme Court will have to decide that thing for once and for all, whether the various types of reservation now with this EWS reservation being upheld by the Supreme Court by a majority of 3:2, it has to be decided whether the Indra Sahani judgment is violated by these reservations across the country. Then in Indra Sahani, it was also said that rule of law, that law is above all, is also a basic feature of the Indian Constitution. Then you have S.R. Bommai, which said that now there was a point in time when the union government was imposing president's rule just to throw away the elected governments at states. So president rule was being used by the union government to dismiss elected state governments. Now, the Supreme Court in this particular case said that emergency, this president's rule, cannot be imposed like that. State governments have a right to, within their states, to function, to rule its own people. The exercise of the central power under 356 is violative of the basic feature of the Indian Constitution. Is that clear? So in S.R. Bommai versus Union of India, it was held in 1994, again a constitution bench judgment. So these are some very, very important constitutional judgments that we are just giving it to you in case it comes. Fundamental rights. Fundamental rights are given in under Part 3 of the Indian Constitution. They are justiciable. That means they are enforceable in a court of law, unlike directive principles of state policy. So you have various fundamental rights. Okay. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. Very, very important. Okay. Very, very important, guys. Very, very important. All of you. Shubham, we will discuss about wagering and contingent contract in another class. We will have another short one class. Okay. Don't worry. Okay. One short revision we will have in the next class. I'm going to revise. Take care of wagering agreement and contingent contract. Okay. I have a lot. We have 3 passages. We have 3 passages now, guys. Okay. Now, Article 14 says equality before the law and equal protection of the law. That means everyone is equal in the eyes of law, and equals must be treated equally, unequals must be treated unequally. It says that the state shall not deny to any person equality before the law and equal protection of the law within the territory of India. So you have equality before the law and equal protection of the law. That means equal should be treated equally, unequal should be treated unequally. Now, equality before the law is a negative concept which ensures that no special privileges to anyone. Everyone is subjected to the same law of the land. It is equivalent to the corollary, that rule of law in Britain. So everyone is under the same law. The exception to the rule of equality before law, it's not an absolute rule. Diplomats have special laws. President of India, state governors, public officers enjoy some more protection, some more privileges under the law. It is not absolute. Now, equal protection of law means it's a positive thing, which says that Mukesh Ambani pays different tax. I don't pay that much amount of tax. Tomorrow, the government cannot say, "Arey, Mukesh Ambani is paying so much tax. Why are you not paying so much of tax?" Equal should be treated equally. Unequal should not be compared with equals. Can you compare apples with oranges? No, you cannot. Law should be equal and equally administered. That should be treated equally without distinction to race, religion, wealth, social status, or political influence. So, equals should be treated equally. Unequals should be treated unequally. Okay. Is that clear? Now, there is one exception to it, and they are reasonable classification. Okay. Now, this is very, very important. Okay. Okay. The only exception is reasonable classification. The state can make reasonable classification insofar as providing equality is concerned. Now, people from one category can be given special status. EWS is being given special status, right? That might be opposed to right to equality. But just because these people are below particular wealth, they are being given some advantages. Article 14 forbids class legislation and permits reasonable classification, intelligible differentia, and rational relation. Now, classification must be founded in intelligible differentia, which distinguishes those that are grouped together from the other. So, if you can carve out a group of people from the rest based on certain parameters, you can make special laws for them. Rationalism, there must be a rationale between what is sought for by this law. The rational nexus between EWS is the fact that some people might be from the Brahmins, might be from the upper caste, but they are not financially so strong. For them, that classification is made. So the object of the law must be taken into account while we are deciding on right to equality. Is that clear? Is that clear, everyone? Okay. Okay. Now let's practice some questions. Okay. Let's read the passage. First, act of God. First. Are we done? Okay. Moving on to the next slide. Okay. Okay, the first question. The first question is up there on your screen. Is it an act of God? No, it is not. They cannot plead act of God in this present case. It cannot plead. There were certain dynamites. It's not an act of God. Okay, the next question. Okay, again, very good. A cannot plead act of God. Somebody is spraying some pest control thing. It is not, spray some chemical. It is not an act of God. So is it a natural activity? It is a man-made activity. That's how you should answer. This is how you should see. Okay? Yeah. Question number 4. Earthquakes were common occurrence to this place. So the correct answer over here is, since earthquakes are common occurrence over here, he cannot take the defense of act of God. He cannot take the defense of act of God. Is that clear, everyone? Brilliant. I think you guys might not be able to see these slides properly. I'll just switch off my video so that you can definitely watch it properly. Okay, I'm here in front of you itself. Just that. Okay, let's see the correct answer. Let us see the correct answer. Option A. Now, act of God is an accident caused by extraordinary natural forces, whereas negligence is an effect of ordinary natural forces. Is that clear? Okay. I'm moving on to the next passage. Moving on to the next passage. Read it very carefully. Okay, are we done? Okay. Are we done? Next. Basic structure. Okay. Okay. Moving on. Moving on to the question. Yeah. Option D is the right answer. Parliament has the power to amend the constitution. Supreme Court, President, state legislature do not have. Basic structure has never been mentioned in the Indian Constitution. It is being created by the Supreme Court. Is that clear? Okay. Which is not a basic feature of the Indian Constitution. Secularism, yes. Rule of law, unity and sovereignty, yes. Right to work. Let's see the correct answer. Right to work is not a feature, basic feature of the Indian Constitution. So that is how, and you have to be fast. Incorrect. The power of the parliament to amend the constitution is absolute. Absolute. Subjected to basic structure. So the correct answer is option A. Next. Role of Keshavananda Bharati's judgment with regards to basic structure of the constitution. All of the above. So you have to be really quick. You don't have too much of time. Remember, what we are doing right now is keeping in mind your ALET and CLAT examination. Read. I'll just disappear myself. Okay. 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 Let's see the questions now. Let's see the questions. Yeah. The moment you see 17 years, that's it. 17 years. Right? Next question. Oh my God. Again 17 years. Wow. Okay. What is this? He entered into the contract at 17, but later, okay, doesn't make any difference. Yes, the answer again is the contract is void ab initio again. Again. 16 years. Oh. Borrowed 2000. He cannot get refund. He cannot get refund because it was in 16 years. No. He cannot get anything refunded. He cannot. Option D. Option D again. Are you understanding how to solve these questions fast? You have to be absolute fast, right? Yeah. Right? This is how you should fast. You have to be little fast. Okay. Mohari Bibi Damodar Das. Did the court hold on a doctrine of estoppel? A court has should be applicable in case of minor contract. No. False. The court held that the doctrine of estoppel does not apply in the case where a person knows the real facts beforehand. Okay. Let me read option D also. The court held that the doctrine is applicable only in the instance where a person knows the real facts beforehand. Does not apply. Is applicable. No. It's not applicable. This is false. So the correct answer is option B. I just got confused between does not apply and is applicable. See, at my age also I get confused between one and the other word. So you have to be very precise, very careful, right? Now, very important announcement on 11th of December, this Sunday, we will come up with ALET 2023 slot-wise detailed analysis. So do not forget to join us on 11th of December, this Sunday, with the ALET 2023 analysis. Do get your BYJU'S exam prep test series. If you haven't, All India mock is already there. Do follow us on our Instagram, our YouTube channel. Do like our Facebook page. Do join our Telegram channel. And do not forget to download the BYJU'S exam prep app. All the very best for 11th of December. All the best. God bless you.